or Zelle Quick Pay, because these, once you pay them, it's the same as if you mailed them cash. There's no way to track it or get it back. Even if you call your bank, they have nothing they could do about it because the money has already been wired. Besides verifying if your broker is licensed or not, you can also use the masslandlordrecords.com to see who exactly owns this property. A lot of the times, by using third-party websites, the one who makes the post is often the landlord owner. So you might want to double check and see if it's the same person. If it is, you're pretty much safe, but if it isn't, you might want to ask more. And you might even want to ask them, who is this landlord?
And Vincent's right, use the registry of deeds. That's available to you, and they will give you that information.
And usually, if a deal is too good to be true, then there's probably a problem with the deal. So by using the huduser.gov or the rentdata.org, you can help to check what the rent is in the area or what the previous rent is in your building. And if what they're offering you is half the price it usually is, then there's probably something to be afraid of, and you might want to double check and ask yourself the previous questions once again. Well, what do you do if you do get scammed? Like I mentioned, you could seek us, or the Boston Police, the FTC, the FBI Internet Crime Center, or the AGO's office, or even the Suffolk DA Special Prosecution Unit. But overall, even if you seek them, all you would be doing is reporting a crime and preventing anyone else from being harmed. There's really little chance that you would be able to get your money back. So remember, the best course to prevent being scammed is to just avoid being scammed altogether.
Really good advice. And the Suffolk County and the State District Attorney's Office will only be too glad to help you in your search or just see exactly what's happening.
So after deciding on and applying for the housing of your dreams, so what fees can you be charged? Well, by Massachusetts law, you can not be charged an application fee, a background fee, a holding deposit, or a credit check fee. But in fact, your brokers can charge you for a finder's fee, a broker's fee, but they also can't charge you for a pet fee or amenity fee. While a pet fee is not allowed, there are actually a lot of brokers or landlords that will charge you a pet fee. You could choose not to pay it, or you could choose to just give up on the housing, but so can the landlord refuse you. So a pet fee is actually quite common in Massachusetts when a lot of people own pets and want to live in an apartment that will allow pets.
And Vincent, what he's getting at too, these landlords, these phony landlords, will ask you to give them a rental fee or something like that there, and you pay it up front, and you're never to see it again. It's not part of your escrow account. It's not part of anything. And we just had a big case right here in Boston on that.
Right, oftentimes a lot of scammers will ask you for an application fee, and that's the money that they're going to scam away from you. So if that does happen, you should be very wary. So regarding the types of tenancies, there's a tenancy for years.
Just ask, does anyone know anything about tenancies other than this broker right here? Does anyone know anything about a tenancy? No. Okay.
So the four types of tenancies that exist are the tenancy for years, the tenancy for period-to-period, and will and sufferance. The one that most college students will deal with is the tenancy for years, where you'll be signing a lease for a year or a period of time, and then at the end of the lease, you can renegotiate for another one. The tenancy for period-to-period is actually less common, but it's what happens when your tenancy for year ends, but both the landlord and you agree that the contract can continue for another period of time, and it's basically a tenancy for years that renews by itself, like a subscription, and there's no need for a new contract. While tenancy at will is if you were to move in and you agree that you would stay for as long as you want, and the landlord can also allow you to stay. But then the tenancy at will has a major fault, which is that the landlord can kick you out whenever you want, and you might have to leave whenever they ask you to.
They'll file what they call a notice to quit. And then you're at a disadvantage if you're at a tenancy at will. At will means that the landlord and yourself have the ability within 30 days or less to end that tenancy.
And a tenancy as sufferance is the same as a trespasser, except that you've previously stayed in this unit. So if you have been evicted or you've been asked to leave, or you haven't even paid rent for a while, but you still stay at the unit, then you are currently a tenancy as sufferance. So one of the major problems that we've faced is that sublease has been a growing problem. Because a lot of the units, a lot of the leasees, after renting the apartment, they don't want to stay for the summer, then they still have to pay rent. So what they do is that they use these third-party websites to seek out people to continue their rent or to sublease the unit to them. But a lot of the times is that they refuse to sign a standard sublease agreement because the landlord actually doesn't know about this. So what may occur is that the landlord finds out that their unit has been subleased without their agreement, and they can kick you out. So even though you've paid the rent to the leasee, but because they don't even have the right to sublet you the apartment, and you don't have any guarantee of your own, you could be kicked out without your money back in any way.
Not only just that, just say there's 3 women, 3 men in an apartment. We just got a case the other day where one of the roommates moved out and sublet the apartment, which wasn't allowed under the original contract. And they went after the remaining 2 students that were in there. This is in the North End, and evicted them because they had breached the contract. That's why what Vincent is saying, you have to read the contract to know what you're signing. Don't sign away your rights like that.
So when you rent, you always want everything in writing. You want a lease, and preferably, you want all the terms that you guys have agreed on that lease. Especially in a lease in Massachusetts, the parties involved, the property address, the terms, and the amount of rent, and the deposit and fees all have to be written. But usually, the utilities, occupants, or the right to entry, or even the maintenance and repairs, these are usually optional and depends on the landlord or you if you want this written into your lease. If you want your rights protected, you actually want this written. And you want to check and see if you could sublet if you wish to do so before signing the lease. So what can you be charged for at the start of your tenancy? At the start of your tenancy, all the landlords can ask you for is the first month's, a last month's, and a security deposit, and even the cost of a new lock and key. But any more, it's illegal under Massachusetts law. They can't ask you for multiple months of rent in advance. And most of you might not be aware is that the security deposit should actually be held in a separate interest-bearing bank account, where there will be interest generated, and at the end of the tenancy, it is expected that the landlord will return this interest to you, and at the same time return your security deposit unless any maintenance was done.
Funny Vincent brought that up because we just had a case where the security deposit was, say, $1,500, and then the landlord says the 3 students did that much damage to the place, and then they don't know where to go, they don't know what to do. They have to contact our office or the Attorney General's office or bring a civil small claims action.
While most property owners will owe property insurance, which will protect their property in case of damages, you are unprotected by property insurance. You can actually seek to buy renter's insurance, which will only cost $15 to $30 a month to protect your own personal belongings in case something does happen with the unit. So if the unit does get damaged or if things do get stolen, renter's insurance will help cover your damages as a renter.
And believe me, talk to your parents about that. You may be able to hook on to their insurance on their homes or through their agent or agency.
So in Massachusetts, all apartments have to follow the sanitary codes. So if something does get broken in your apartment and you seek your landlord to fix it, but he refuses to do so, you are in fact allowed to withhold your rent. But it would be strongly advised against to do that because we recommend preferably resolving the problem with your landlord themselves and hopefully having the problem fixed.
You want to get out in front on this issue here. you don't want to withhold the rent and to have him then move for a 30-day notice to quit or a 14-day notice to quit. You want to make sure you're out front on that. If there's a problem with the apartment, report it and go from there. But like Vincent said, get to Consumer Affairs in Boston if you're from Boston, or get to the Attorney General's office, or get to the Suffolk County District Attorney's office. Don't withhold it and put yourself in a precarious position where they then take you into court.
And finally, discriminating against your renters is not allowed in Massachusetts. So your landlord cannot choose to evict you or deny your application just based on race, sex, or etc. Thank you so much.
No problem. Does anyone have any questions about what we talked about today? And I sort of apologize. I'm not a consumer advocate. I just started at the agency 6 months ago. I was a criminal lawyer, criminal law defense lawyer. So this is a whole different thing for me. It's a lot of civil law, and I'm just learning it as I go along. So if you have any questions, put your hands up and speak up. Don't be afraid. Thank you so much for your attention. We appreciate it. Thank you.
Thank you.
Thank you. We hope it's been informative in a way that you guys can, you people can digest it. And so you know your rights. And it's better to be informed than come in after the fact and not know what you're doing. And one thing I will say to you, Vincent's going to be a lawyer. We were told the first day of law school, an oral contract is not written, what do you call it, is not enforceable because of the paper it's written on. So like I say, don't do anything orally, get it in writing. Thanks again. And don't hold it against me that I'm a Harvard guy and we beat you in lacrosse 2 weeks ago. Thank you so much, appreciate it.
Peace out. Peace out.